Hey, Georgia Peach here. I just wanted to quickly thank Garrett Martin for sending us this lead. It's a really good, it's a long argument, it's interesting, and it gets heated. So, yeah, I really liked it. Thanks, Garrett. Hope y'all enjoy.
Versus Joshua Ray Needham, case number 22-00895SM.
Andrew Stevens on behalf of
Taylor Reese, Assistant Public Defender, on behalf of Mr. Needham. Asking for Mr. Needham's appearance to be waived. At this moment, he is being brought up from downstairs for being absent.
Thank you.
Thank you, Your Honor. At this time, the defense would be moving for a dismissal with prejudice due to prosecutorial misconduct. I filed a Ricky Jack motion in this case back in May. That was never complied with. It's also against clear statute or clear case law that the prosecution is providing unredacted police reports in the first place, since I both asked in my original discovery demands and in a Ricky Jack motion for an unredacted report, and that was never complied with. I would be asking for dismissal of prejudice.
Is that an appropriate remedy?
It is one of the remedies allowed by the discovery statute.
Thank you. I'm not sure that that's the appropriate remedy under the statute. If evidence can be excluded but dismissal with prejudice, I'm unfamiliar in my years of practice as an appropriate remedy. But here, let me save the court time. The people made the strategic decision today, even though we've had great contact with Ms. Toms, the victim, to not, we advise her not to appear because Mr. Needham also has 2 pending felony matters in circuit court, one of which Ms. Toms is a pending victim. We felt that from a strategic standpoint, not.
Mr. Bourdon, I'm going to move you back into the waiting room. We're getting some interference from your location, sir.
Okay.
Just hang tight. We'll bring you back. Thank you.
Thank you. Thank you, Judge. We made the strategic choice to not place Ms. Toms under oath on the record in light of the fact that she would likely be or potentially be testifying in a felony matter against Mr. Needham. And if, frankly, Mr. Needham were convicted on that felony matter, this misdemeanor matter is largely irrelevant to that fact. And so at this point, the people are moving to dismiss the case, this pending matter 22895 SM without prejudice because of the pending felony matters that Mr. Needham has. Again, 2 different ones, one of which includes this same complaining victim, Ms. Toms.
Any additional?
Just, Your Honor, that the filing of these Ricky Jack motions has gotten ridiculous. It's been almost 2 years since that office lost the case. And the fact that on every assault case, we are still continuing to get redacted police reports against the rules has become unconscionable.
So I had one in this case as well.
Yes, I filed it on May 22nd.
The notice of intent to file.
Which is what we were doing on your request.
Yes.
Based on the paper.
Yes.
So.
Which is also not in motion.
The motion never came. I have not received a motion.
Then, Your Honor, if that's the stance the court's going to take, I'm going to go back to filing full motion.
You're able to file full motions, but my understanding was once the prosecution received notice of something that largely these were resolved.
And they were for a while, they are not.
Okay. Well, you can file what you wish. I'm just saying that, yes, the court did ask for a notice of intent to file a motion to compel because we were getting these motions that were multiple pages. And the prosecution would receive it and look into it and then it would be resolved. And then I would have a stack of papers on my desk. And so I said, let's start with the notice of intent. Your initial response was no, you're going to move forward with the motion. motion, we did that for a period, and then we started receiving the notice of intent. The court never intended the notice of intent to file a motion to be in lieu of a motion. It was just sort of a courtesy to the prosecution that this is what's the time. But if that's an additional step that you're not willing to do because of the court's permission, that's fine. I will also say that following a notice of intent on May 22nd, the court would prefer not to have a motion to dismiss the day of jury trial. If you've not received compliance within however many days you deem is appropriate, then that should be brought back to the court.
Understood, Your Honor. It just should not be the defense's job to make sure the prosecution is doing their job. It should be done by the.
So I issued an order. I don't remember that case.
I do have that order in front of me.
What's my order? Mine.
The order was on Brandon Charles Johnson. And it says, on or about October 27th, 2022, defendant Brandon Charles Johnson, by and through his legal counsel, Taylor Wicks, of the Ingham County Public Defender's Office, filed a motion to compel discovery to receive unredacted police reports. Following a hearing on November 8th, the court determined that the Court of Appeals ruling in People v. Jack is not inconsistent with the Crime Victims' Rights Act as it relates to victims' privacy. Wherefore, it is hereby ordered that the Ingham County Prosecutor's Office shall produce an unredacted police report to defense's counsel consistent with People v. Jack. Ingham County's Prosecutor's Office may seek a protective order pursuant to MCR 8.6.201E. It is further ordered that this order applies to all cases currently pending with the Honorable Cynthia M. Ward as of the date of this order.
So maybe I need to change the order because it says pending as of the date of that order. Mr. Stevens, what is, I understand that, I understand your role and we don't get to speak to the prosecution as to the policy as to this, but this is really, I don't think I've discarded any of the motions I think they're all in my office, even with the cases that have been. I want to see how I stack them.
As the court just indicated a second ago, I certainly don't speak on behalf, and it's more, is it my place to speak on behalf of the appointed, hopefully soon to be re-elected prosecutor John Wayne. But this is an issue that I have dealt with in multiple courts, not only certainly at the moment this court, before Judge Flores and also in 54B. Our office is certainly aware of what the Jack case and subsequent case law says. But as the court pointed out in its order, people are entitled to seek protective order if we want to. Discovery rules also indicate that we have to comply within 21 days. And if there's no motion for, specifically no motion for a unredacted, which there, in light of this case and sort of using this case as the springboard, there wasn't one. And so if they're not requesting or haven't asked for one, we still have time to seek a protective order.
Is it part of their appearance of demands?
Yes.
But that is a morphing standard because some of these cases are older than others. And so before some of these cases, when we ultimately created the police report and automatically redacted, it wasn't initially a part of their discovery demands. That has subsequently changed. Now, it may be a request in this specific case. Here is ultimately what I would like to see happen. In this case, in this court, in all of our courts, this issue is a hotly contested issue, but it doesn't need to be. I've asked my APAs to remain, I guess I'll wait just a second. To remain in continue with ongoing civil communications with the assigned public defenders for each court. I don't see why this scenario has to result in notices of intent to file motions or even motions. This is the exact same thing I've said to Judge Flores' staff. The public defender's office wants unredacted police reports in cases that we charged or authorized before some of this case law came out, or in between. Our office staff is aware of the obligation. An email to the APA that simply says, hey, we received a redacted police report in the following cases. Can you please send us the unredacted unless you intend to move for a protective order? If you don't intend to seek a protective order, send them over. Each one of the district court APAs that I supervise, I have given them clear instructions that unredacted is what they're supposed to turn over, unless we intend to seek protective order. Why it cannot be handled in a civil matter outside of, as the court indicated, reams of motions, when it doesn't need to be, is beyond me. I simply don't understand that. And so, again, from the prosecutor's office perspective, we are aware of our obligations. And I'm coming into this a week before, but the thing, what is sort of a microcosm of the circumstances, the number of emails that were exchanged Friday afternoon about this, not one did I receive from the public defender's office requesting, hey, I filed a notice of intent, didn't receive an unredacted. I also see that you didn't file a protective order or request for a protective order. To your point, Judge, why did this have to be brought up this morning? Why couldn't this be ironed out like civil individuals via communications? We had no problem turning in jury instructions. We had no problem advising your staff if you were or were not proceeding with trial. But nowhere along the line was there any communication about redacted, unredacted. And it just doesn't need to be happening that way. So ultimately, my advice to my staff and the attorneys that I supervise is deal with it outside of the rules. We don't need to exercise the discovery rules or motion practice if we just turn it over. If they just tell us what they need, I've given them the instructions to turn it over. So I'm not for 1 second going to say I know what their discovery demand says in this particular case, because I looked at it in anticipation of today. And so I just would be hopeful that whomever was handling the case before, and I know that this court has sort of had a revolving door of APAs over the past 6 months, but at no point coming into today was it ever addressed with me. And then to effectively be ambushed with the issue, and there really wasn't a motion, I think is just poor form. And it, again, doesn't need to happen that way.
Well, I will say, I do believe I have a full-fledged motion on a matter that's scheduled before the court on July 20th. So I'm a little less than asking, I believe. I'm questioning your statement, not that I don't believe you, because I know your reputation, you're upstanding. But the whole idea that the prosecutor's office knows their obligation, that they're supposed to hand it over. I have a stack of motions, and I'm assuming that Ms. Wicks, who has been with me for a couple of years, and I know her reputation, and she's upstanding, wouldn't file these motions having received unredacted police reports. So she's not getting them. That office, well, I'm not speaking for her and her office. The cases that are pending with me and which she's involved, she's not getting them.
Your Honor, it is in fact every assaultive case our office gets.
I
It is
understand.
nice that Mr. Stevens thinks this can be done civilly off the record, but it has been nearly 2.5 years. Their office should be complying up front and not something I should have to send an email.
Respectfully, we don't have to. We do not have to upfront do that. We have 21 days to comply with discovery, yet we give them unredacted within 24 hours of an appearance. We still have another 20 days to decide what, fine. If that's the stance they want to take, then I'm going to direct my discovery staff and my APAs to not send them discovery for 21 days, because that's what the court rules.
Hold on.
So respectfully to them, now I understand that some of these cases we're probably referring to are old, but nevertheless,
So you're saying 21 days from this appearance, which the court received on April 10th,
and yes, this would be an example of,
appearance and demands.
yes,
So is this demand?
It should be. That there should be a demand for any and all police reports in the matter. Unredacted is what the law requires at this point.
So number 11 says police reports and interrogation records concerning this case, including audio, video evidence relating to interrogations, interview, except parts of the report that concern activity investigations. Is that the part that you're referencing?
Let me pull up our documents.
Do you need to see it?
Yeah, Your Honor, if I could approach.
You may. And then my question is, Mr. Stevens, is something that would be more spelled out in the demands? You said you know your obligation.
yeah. Here's, now, as I understand it, over time, they have changed their appearance, or I'm sorry, discovery demands to actually articulate unredacted. I briefly looked at, I have a copy, I briefly looked at it, and I don't see the word unredacted. Nevertheless, again, this is ultimately my point. Whether this was an old case before they changed the language in their appearance demand, or a new case where, as I indicated, it's my understanding they have changed their appearance demands to say the word or use the word unredacted. We are aware of the obligations, but some of these cases predated some of the case law, and were charged and gave discovery immediately. But we're allowed to give discovery with a buffer zone. And so if they want to wait 21 days before we give discovery, if that's what they're demanding, or we can work through this in a more civilized way instead of trying to ambush people in front of courts. And I'm not saying just Miss Wicks. I've seen it across multiple courts where it doesn't have to turn into motion practice. Just like you, Judge Flores has a stack of them as well. But I've told both the court staff and the APA assigned there, work through each one of them. If we don't need a protective order, send out unredacted. We are complying with our discovery request immediately.
And so does that mean that you're sending redacted?
Yes, at least some of these older cases. Some of the brand new ones, I don't know the answer to that.
Your Honor, this case was issued in April. This isn't that.
I mean, I'm thinking,
And also
when you say predates the case law, I'm like, well, the case law's been around for a bit.
Well, Jack's, yes, but some of the newer case law was within a few months. And without getting into, actually, no, I'm not gonna go down this rabbit hole as to some additional comments I have from this perspective. This is my ultimate point. And I know that Needham's case is being dismissed. We've arrived at the same conclusion in a different way. So we've used this as sort of a springboard into a soapbox on the issue. All I'm asking for is some civility between the two offices, because it really, I've never seen anything like this. I've never seen this amount of hostility between the two offices, and it doesn't have to be this way. Like I said, I'm a bit taken back that this preliminary matter had to be addressed when in the Friday, all day Friday, and in the entire weekend, Mom was the word on this issue. And it didn't need to be that way. Because had the request simply been, I want my unredacted, I would have sent that out immediately, probably along with the jury instruction that I gave public defender's office in anticipation of today's jury trial. I just don't see why it can't be handled in a more friendly way.
Your Honor, that would have been the third time I would have asked. It would be 0.5A in our discovery demands. It would have been the third time I asked. I shouldn't have to be asking for the prosecutor's office to comply with what the law currently stands as, let alone multiple times. It started civil the first year, learning curve, great. We are so far beyond that at this point. Jack was a 2021 case. It has been an ongoing issue for so long. And the ruling was clear. And I understand that, yes, there's been updated case law that the Crime Victims' Rights Act does not conflict with Jack. I will fully concede that point to Mr. Stevens. But this has just been an issue for too long, and that's why it's gotten uncivil, is because, as Mr. Stevens has stated many times, their office is aware of the requirements and seem to just continually not comply.
First, I will say, I don't think the following motion makes something uncivil. It just makes it certainly more formal. Because I don't want the whole idea that motion filing is uncivil. It's part of our practice, is part of what we do. Just having to make a request 3 times, I don't know how those requests, I don't know if it's been to the same individual. I don't know if Mr. Stevens' guidance to the APAs he supervises came after those 3 requests. There are a lot of unknowns. I don't know why this issue continues to rear its head. I'm happy to hear that the prosecutor's office understands its obligations, and I appreciate the guidance that you share with the court, that you gave your APAs that you supervise. It would be my hope going forward. I may have to revisit my order, but it would be my hope going forward that this can really not be an issue, given the guidance that you.
I want it to be not an issue anymore.
Same.
And let me clarify. By no means am I suggesting that filing motions is handling things uncivil. It's the words that are said outside of that I've seen in multiple courts. It's in this very issue came up late Friday, and I worked with the chief assistant on throughout the weekend, because there are email communications that are directed at us and to the court that are threatening in nature, and it frankly needs to stop. Whether they want motions need to be filed or not, that's fine, but to come at our office and our respective APAs in disparaging ways is unacceptable, and that's the civility that I'm requesting. And I recognize that Ms. Wicks probably doesn't want to ask a 3rd time, but she also knows and I agree, but she also knows she's never dealt with me once in this courtroom or on this case. And as simple, hey, I asked, never got, what's your take, isn't that hard. We do it of them constantly. I do it with their senior staff all the time, many of which I've worked for more than a decade, have no problem with it. That's what I'm trying to remedy here. I don't want there to be hostility between the 2 offices. It doesn't have to. We have our own jobs to do, but at the end of the day, we can still talk to each other, and that's what we're missing. I tell the PD's office, and certainly the representatives that are here today, but also this court, if I have to do this in front of every judge in the county district court, we are working through this problem. We are not perfect in how it may be handled now, or maybe every single case, but 9,000 plus cases a year, we're going to screw up some stuff along the way. We're working through this problem. But in order to give grace, you gotta give it. And all I'm asking is a little civility when we may, in this case, may have screwed it up. Because it is very simple to give over an unredacted police report. And I know disclosure demands say reports, but as I told the court, I, coming into today, didn't even look at it. It's one of the last things that I look at, even though I have an obligation to, because I end almost every conversation with a defense attorney with the following sentence: if there's anything else you need, just let me know. Because I expect them, they need something of me, given my obligations that I have not provided, they'll let me know. And notices of intent or motions, sure, they'll grab my attention, but it doesn't need to come to that if you just simply let us know. And that's ultimately my final take on, like I said, Mr. Needham's case is sort of been a springboard into a soapbox moment for the court, the PD's office, and my office.
So the court's unclear as to whether your guidance now will change to your APAs. So my takeaway is that the demand, the appearance and demand that the public defender's office issues is their request for the unredacted police reports, assisting with people with redacted.
My guidance is very simple to my APAs. If release the unredacted police report unless you have or you think there are grounds for a protective order. If so, make those moves. If not, it goes over. Period. If you've noticed that we sent an unredacted initially, fix it, because that's our obligation.
So the cases that are working through are cases that predated Mr. Stevens' guidance, is what I'm hearing. Yeah, I don't know if that's
Potentially.
true or not, because like I said, I have one that's sitting. I don't know, actually, I don't know, because I don't know when you gave guidance, you could have given it first. So,
I can tell you that I've been dealing with the issue pretty frequently with Judge Flores and the assigned prosecutor there, and that is the guidance I've been giving him since really this issue landed on my doorstep. I don't know, I can't give you an exact date as to when that was. I would say within the last 30 days-ish. But it has been, what I said a second ago, that has been my guidance to him. We do have, as the court was probably aware, I'm sure his office is as well, assignment changes that are coming up, I think next week they become effective. And going into that, I intend on hosting a district court staff meeting where this is going to be a topic, of course, and I will be laying out the exact same guidance I just informed the court that I provided that individual APA in that court to all of them. Because, like I said, I recognize what our obligations are, and while I know that I've relayed that to one, I want all of them to know that, and I want to have it as uniform as I can make it.
so in what you shared with the court about your guidance is send it, I don't know if you said unless, but I heard unless.
There was an unless.
Send it unless.
Because the new case law indicates that we can seek a protective order, but we can't simply say, out of concern for the victim. We can't use generic or generalized statements. And so each case, if we want a protective order, needs to have specific and articulable facts or circumstances that would warrant us to seek a protective order.
Yes.
So, for instance, as an example, I'm not citing to anything specific. If, for whatever reason, in a police report, the complaining victim now lives at a different location where the crime didn't happen, and that's listed in the report, we may have circumstances where we could articulate some redaction of the police report.
So would you agree that I should have a protective order, proposed protective order on my desk on the 21st day?
Yes,
Okay.
yes. To strictly comply with discovery, in that if we send out a redacted within 21 days to comply with the rules, if we want to seek a protective, we have essentially within that time, or the filing of a motion within that time that may be heard after the 21st day. But yes, to strictly comply, which, as the court can maybe see, that is why my guidance starts with the default release on redacted, unless you look at it and you see something that needs to occur. And by most accounts, most of your cases, the way I know that you and the other judges run your docket, from the time that they're arraigned, time when we would receive their appearance, they're probably on their first, if not their second or final pretrial within that 21 days. So that, and the court can certainly tell me if I'm accurate or at least close to accurate on the timing. So at least there should be at least one read from our office by the assigned prosecutor of a file where we could decide, do we or don't we need to seek a protective order. So I do agree with the court in that regard.
I'm sorry, do we need to let administration know we're not having your time? Sorry, no. Thank you.
So I think I answered the court's.
You did, I'm just trying to, I mean, unfortunately, I don't believe this is the last we're gonna have of this.
I'm sure we're not, Judge, and admittedly, this is now I recognize when Jack was decided, but there's still case law that comes out of it. But it essentially undercut decades of practice before. This is new even in I'm relatively young in my career, only having practiced for 13 years, but up into the last 2, this was the practice. And so it's an old dog, new trick circumstance. Now, is that an excuse? By no means. But there will be, as the court just pointed out, there will be, has been, probably going forward, some amount of growing pains, which ultimately punctuates my leading point to this. I know Ms. Wicks doesn't want to ask a third time, but at the same time, had she would have had it immediately, at least for me. And what I'm saying to Ms. Wicks and the Schroeder's here and representatives of PD's office, and if they want to walk it right on back, it's the same thing I tell administration all the way up to Mr. Watson, who I've dealt with for years. But I'm also saying to the court, I'm trying to create uniformity in this issue. And that's some of the growing pains that we'll likely have currently, and I'm hoping to minimize some of that going forward. I know that this doesn't necessarily quell the court's concerns or even the PD's office concerns, but this is what I'm trying to do.
Your Honor, to Mr. Stevens' points, even if I had, by the time I learned middle of the week last week, if I would have gotten an unredacted report from Mr. Stevens, there would have just been stipulation to adjourn, so I could reach out and do an actual investigation in this case. I don't know that it would have changed, it would have changed the words I said this morning possibly, but it wouldn't have changed any of the outcomes.
So on June 5th, when we were last in court, did not.
Your Honor, I was not here that day.
And I certainly wasn't here that day either, so I don't know if I necessarily know where the court was going with that question, but I'll just make the record clear, I wasn't here either.
Well, we have Mr. Needham's case. I don't know if I just lack context, because it seems to be a systemic issue, at least I guess with me and Judge Flores, because I do have a stack in my chambers, but I would imagine there's an equal amount, hopefully an equal amount or an excess of that number in my office of cases where the information has gone out correctly, consistent with people versus Jackson.
Not in an assault case.
Well, it is an issue that I'm gonna pay close attention to. Mr. C, because I extend to you an opportunity to have your guidance take hold, but certainly not at the expense of defense's needs and duty, quite frankly, to zealously represent their clients. So I would pay close attention to this issue.
And I welcome that. I would even call it, I welcome that challenge. I've never once in my career been accused of or had any sort of discovery violation substantiated against me. And this is ultimately that. And so this is an issue that I work on nearly every day. And I certainly thank the court from the perspective of a sort of forward-looking approach to seeing that this and the guidance that I've informed the court that I offer to take hold. I appreciate that. I think that's sort of the grace that I've been given, and I'm hoping that in that time we can fix it. And again, hearing what I'm saying in court today, I'm hoping that the PD's office, its representatives here, and then as an office overall, can take what I'm offering here and understand we are not trying to be intentionally obtuse. And so we're working through this problem. Full stop.
As it relates to People versus Needham, case number 22-00895, Mr. Needham, will you please stand? And state your first and last name on the record.
Joshua Needham.
All right, thank you. All right. Counsel, as to the jury trial, we're not having a jury trial. The people has indicated that they're dismissing this case without prejudice. The court's going to grant that. Is there anything else that needs to be addressed on this record? Is something else holding Mr. Needham? Oh, yes.
To the court's question, nothing additional on behalf of people.
And nothing from defense.
Thank you. And I don't think the